This week, we want to talk about regional human rights organizations. You would think that the United Nations system for human rights might be a dominant system that would command most of our attention. But in my judgment, when we get to the regional human rights bodies, we're going to see something far more effective and far more interesting. And I particularly refer to the work done by the Council of Europe and its organizations, particularly the European Court of Human Rights, which we'll look at much more closely. There are three of these regional organizations that we want to look at. The African Union, which in the human rights regime is still developing a path for a court. We won't yet see much jurisprudence from that court. We will see quite a lot done by the African Commission on Human and People's Rights. In the Americas, the Organization of American States has organized the Inter-American Court for Human Rights, and we'll look at some of its cases through your class presentations. And in Europe, the Council of Europe. And the Council of Europe has organized the European Court of Human Rights, which we'll go to first. Our learning objectives for this session are to make sure that we understand the reach of these regional organizations and understand their significance for human rights. We want to understand that there are regional treaties which bind nations to a regional regime of human rights, and we want to come to appreciate the role of commissions and the courts in the development of human rights. And I think when we finish this session, I hope you'll agree with me that we've looked at some of the more important organizations that are engaged in human rights adjudication. First of all, looking back at the UN Charter for a second, the UN Charter actually notes that nothing in the Charter precludes regional organizations, and actually regional organizations are encouraged by the United Nations. I've already identified three that are significant to us: the African Union, Organization of American States, and the Council of Europe. Each of these has a human rights treaty, and each of it has some apparatus to address human rights violations. Let's start with the Council of Europe, which I think is the most important and by far the most interesting for reasons that I'll explain in just a moment. Let's start off by making sure we understand the difference between the Council of Europe and the European Union. Again, these are very easy to confuse, but they have separate organizations, they have a separate parliament. The Council of Europe has a European Regional Human Rights Treaty, and it has its own court system just for human rights. And so Council of Europe is important in many ways, and one of the reasons it's important is that you cannot become a member of the European Union and get the benefits, the economic benefits of being a member of the European Union without first joining the Council of Europe. And when you join the Council of Europe, you have to sign the European Convention on Human Rights, and you have to submit to the jurisdiction of the European Court of Human Rights. And as we see in a moment, this becomes very important for the expansion of international human rights. Winston Churchill began to talk about the United States of Europe in a speech, and I'd like to show you some of the excerpts from that speech. It was given at the University of Zurich in 1946. Later, when the Council of Europe was formed, Churchill gave a speech in 1949 in Strasbourg, where the Council of Europe has its headquarters, and where it has its court. So the Parliament for the Council of Europe meets in Strasbourg, and the court for the Council of Europe sits in Strasbourg. And Churchill points out that dangers still threaten us, even though we have World War II behind us. And he suggests that having a united Europe, respecting its own moral concepts, will be able to win the respect and recognition of the world. So 1949, Council of Europe is organized. 1950, so almost right away, they got to work on having a European Convention of Human Rights. They drew very much, as we'll see, on the Universal Declaration of Human Rights in drafting the European Convention of Human Rights. In 1961, there's a European Social Charter. We'll not touch that in any detail. And then in 1989, an important event for the Council of Europe was the fall of the Berlin Wall. And suddenly, as we'll see, we have a great expansion of the jurisdiction of the Council of Europe and of the jurisdiction of the European Court of Human Rights. Here in 2013, we now have 47 countries and 800 million people who are covered by the Council of Europe. And so let's look through this history quickly. This history began with 10 members. By the time, shortly after that they agreed to the European Convention on Human Rights, it had 12 members, and it continued to grow. So from the original 10, it added another 13. And then look what happens after the fall of the Berlin Wall. We go from 23 existing members, more than double it. And now, not all these countries were Soviet bloc countries, but the movement towards joining the Council of Europe, subscribing to the European Convention of Human Rights, and submitting to the jurisdiction of the European Court of Human Rights really grew after 1989 and the breakup of the Soviet bloc system, and ultimately the breakup of the Soviet Union. And a great deal of population, a great deal of territory came into the Council of Europe. Again, 47 nations, 800 million people. And as you look at the area we traditionally think of as being Europe, it's only Belarus that's an outlier. Belarus was at one time an observer member of the Council of Europe, but that was also terminated, and now Belarus has no direct relationship with the Council of Europe. That is as of 2013. Looking at the organization of the Council of Europe first, there's a Secretary General, much like the United Nations. There's a Committee of Ministers, and notice these ministers now are not justice ministers. They're not prime ministers. These are the foreign ministers of each of the member nations. And we'll see shortly that the Committee of Ministers has a very important function, because the decisions, the opinions, the judgments of the European Court of Human Rights are turned over to the Council of Ministers, and they put pressure on nations to comply with those opinions and judgments. The Parliamentary Assembly of the Council of Europe is called PACE, and it has national parliamentarians from all of the member states. It's interesting, if you visit Strasbourg and visit the chambers where the delegates, where the representatives from the nations are seated, you'll not see them seated by nations. They're actually seated by political parties. So all the socialists are in one area, the Christian Democrats are in another, and so forth. So you find the people who have similar philosophic viewpoints are seated together in this particular parliament. The most important institution for our purposes is organized by the Council of Europe, is the European Court of Human Rights. There's a judge from each member of the Council of Europe. So today in 2013, there are 47 members, and therefore there are 47 judges who serve on this court. They're selected by the Parliamentary Assembly for the Council of Europe, and they're selected from a list of nominees put forward by their nation, but nation does not get to identify a person. It has to come forward with multiple people to suggest for membership on the court. Now, since the Protocol 14, there are 9-year terms. They cannot be re-elected. There's a president of the court, and we'll see in a moment, the court sits in various formations, is the terminology they use, different chambers. There's a grand chamber of 17 members, and then chambers of 7 members, committees of 3 members, and there's also a single person formation. I want to go to the treaty itself for a moment now, and as we've already said, when the Council of Europe was organized, it sat down to work right away on having a treaty now, not a declaration, to govern European countries. And so this committee had 2 really interesting people in principal leadership, a British barrister who had been the deputy British prosecutor at Nuremberg, a person who was very much engaged in the cross-examination of high German officials, was the British barrister David Maxwell Fye. He had a very distinguished career, held office in Britain following this, and served at very high levels of the British government. The French lawyer Pierre-Henri Tigran was another interesting person. He was active in the resistance. He actually, during World War II, he actually organized newspapers that were published, anti-German, anti-Vichy newspapers that were published, and he took considerable risk by being so actively involved. He became an important figure in life in France following his service to the Council of Europe. So in 1949, the Council of Europe heard speeches, including those from Tigran and from Maxwell Fye. Both called for a treaty and for a court. Do you remember back when we were talking about the development of the Universal Declaration of Human Rights? We had people at the United Nations asking for a court and asking for an enforcement device. Australia was particularly strong in making that plea, but once that plea was made here in 1949, the Council of Europe accepted that plea and established both a proposed treaty, and a court. Maxwell Fye continued to be important, and in November of 1950, the treaty was open for signatories. Now let's look at the treaty itself, and I urge you to pull out copies of the treaty and read through them. I've had several protocols, but you'll find in any version that you pick up in the Council of Europe that they've incorporated many of the protocols into the language of the treaty itself, so you don't have to read multiple documents for most of the important provisions of the treaty. I want you to, first of all, look at the at the preamble, I've said that the Universal Declaration of Human Rights became a template for other treaties following the Universal Declaration, and we here see that quite directly acknowledged, that they make a reference to the fact that there has been a Universal Declaration of Human Rights proclaimed by the General Assembly, and they then proceed to draft a treaty that draws quite directly on the Universal Declaration. Just to go through in outline form some of the provisions of the treaty. Let's look at Article 2, has the right to life. 3, prohibition on torture, inhumane treatment. 4, prohibition of slavery. 5, the right to liberty and security. 6, a very detailed provisions on fair trial. And 7, again, great detail on criminal due process. 8, privacy. 9, freedom of thought and religion. 10, freedom of expression. And I want to come back to that in a second. We talk about freedom of expression, but this section 10 does not have the same kind of language that you see in the First Amendment to the U.S. Constitution, which prohibits all laws impacting freedom of speech. Here in Article 10, there's an Article 10 subsection 2 that says this: the exercise of these freedoms, meaning freedom of expression, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society. This clauses like this are called clawback clauses. You give the right, and then you claw back part of those rights. So it's not a statement as clean as the United States Constitution, First Amendment. It is a statement of the right to free expression, but giving to government the right to pull back some of those rights if it's necessary for a democratic society. And what's really being addressed here is the idea that hate speech is not going to be tolerated in Europe. And you'll see a number of instances where that plays out in laws adopted by nations in Europe. There's in Article 11, freedom of assembly. 12, right to marry, found a family. 13 becomes important. You have a right to a remedy. You have these statements in a treaty, but you now have a right to a remedy to enforce these rights. There's a general ban on discrimination, which becomes very important. And there's a rule on derogation. We ought to look at derogation more closely, because we now see that nations, each nation has its own process for entering into treaties, for the officials who are allowed to sign treaties, and for the way that treaties are ratified, or where there's an accession to a treaty. But look at how you can put aside a treaty. Under what conditions can you say, I'm not going to be bound by that treaty? Now, first of all, as we talk about the principle of derogation, recognize quickly that there's some things that are not subject to derogation. You may not torture. You may not discriminate. You may not take away someone's right to life. And so some of the articles, there's simply no derogation. But also, for all rights, you may not derogate except in time of war or other public emergency which threatens the life of the country. Now, think about that a little bit. What kinds of activities threaten the life of a country? Were the attacks made on the United States on September 11th, 2001, acts that threatened the life of the country? As horrible as those acts were, was the country itself, was the very existence threatened. It'd be hard, I believe, to make the argument that that was a time, and those activities would justify derogation. So you only can derogate in time of war or where there's an emergency threatening the life of the nation. You may only derogate to the extent that you have to. So there's a strict scrutiny. If you derogate, it has to be for a purpose which is essential to save the life of the country or to protect yourself in time of war. You may not just go beyond that. So there's a containment on that. There is, as I've said earlier, containment that you may not derogate certain of the articles. There's a requirement that you inform the international community. You've entered into this treaty. You've joined with other nations. You've promised to do certain things. And you now are making a decision that you're not going to do those things. You're not going to provide those protections. And so it's your duty to inform the nations with whom you've agreed and the international community that you're now not complying with the treaty which you agreed to. And you're required now to give that information to the Secretary General of the Council of Europe, and you're required to tell the Secretary General when the conditions for the derogation have expired and when you then set aside your own derogation. There are several protocols that we ought to look at. Protocol 1, Article 2 of the European Convention of Human Rights provides a right to education. Look here at the way we now see these rights that are protected by the International Convention on Civil and on Economic, Social, and Cultural Rights. Now a right of education slipping over into the European Convention of Human Rights, which mostly are first-generation rights, a right to assembly, right to free expression, and so forth. So interesting to watch how this process works. It's also interesting to me as we look at Protocol 2, to look at Protocol 2, which begins to address the capital punishment. And Protocol 2 begins saying that that abolition of death penalty contributes to the enhancement of human dignity, and then makes reference to Article 3 of the Universal Declaration of Human Rights, adopted in 1948, and to Article 6 of the International Covenant of Civil and Political Rights. Look at the way we're picking from the Universal Declaration, placing a provision in the International Covenant on Civil and Political Rights, and then picking up both those provisions and putting them as a basis for the European Convention of Human Rights. We're going to see a great deal more in protocols relating to capital punishment. Protocol 2, Article 1, which again was not immediately joined by all nations in the Council of Europe, but abolishes capital punishment. Protocol 6 and 11 also address that subject. Protocol 7 goes back and adds terms to the very extensive protections which you get in the articles addressing the trial of criminal cases. Now, one of the things that's plagued the European Court of Human Rights is the success it's had. Think about it. Look at the expansion in its caseload. If we didn't know a thing about that expansion, we could just go back and look at that list of countries that are added after 1989 and say, gosh, when you start adding countries like Poland and the Czech Republic, Russia, Georgia, you're beginning to see enormous expansion in the numbers of cases. And one of the interesting things I believe about the European Convention of Human Rights is that because we have a court to interpret these rights and to enforce these rights, we're now seeing something that we really had never seen before in the region largely occupied by these post-1989 countries. Think about countries where it's very risky to criticize your own government. No one would have thought about suing their own government, but now there is a convention that sets up your right to protect your human rights by bringing a lawsuit against your own nation. Sovereign immunity doesn't apply. These countries have entered into treaties and they've promised to abide by these treaties and to provide protection for human rights. And so suddenly we see this enormous growth in caseload of cases before the European Court of Human Rights. And also as the countries enter into the Council of Europe and fall under the European Convention of Human Rights and fall under the jurisdiction of the European Court of Human Rights, as you see, that court becomes better known all the time. As it becomes better known, more people attempt to use it in order to resolve disputes that they have, and that is disputes with their own government. We ought to talk about admissibility. Here now, I'm talking about not admissibility of evidence, but how do you get before the European Court of Human Rights? And there are a set of principles that you have to follow, and we have a videotape which will provide you with a good overview of the principles of admissibility. With these principles of admissibility in place, the workload continued to expand. And as you look at those principles, you'll see that large numbers of the matters that were brought before the European Court of Human Rights were put aside. They were put aside because the applicant had not exhausted their domestic remedies, or they had not properly identified a provision of the European Convention of Human Rights that applied to their situation. For various reasons, they were denied. But that process of denying the petitions was a cumbersome process. Think about it. We have 47 judges. How many decisions can a judge make in a given year? And what we find is that if you have a process in which you have to have 3 judges to make a decision, or a process which requires 7 judges to make a decision, you find that pretty quickly you use up your judicial resources and you don't have enough judges to make prompt decisions. And when that happens, you get this tremendous backlog. And that's what happened to the European Court of Human Rights. It was addressed by the adoption of Protocol 14, which allows a much greater, much more efficient use of judicial resources. And now the formations of the European Court, by that I mean in what numbers do judges sit? Judges may sit, for some purposes, as a single judge and make decisions. And some steps require a committee of 3, some steps require a committee of 7, and then there's a grand chambers. Now, as we look at the European Court of Human Rights, and you look at these chambers, which are actually making the decisions. Now, when they make decisions, if you have a 7-judge chamber or a 17-person grand chamber, you're required to have a judge from the nation against whom the action is being brought on the panel. This is a little bit counterintuitive, but the idea that is embodied here is an idea that really came out of international arbitration. The idea that the way you resolve disputes, as you should have, someone representing the claimant, someone representing the nation against whom the claim is made, and then those would pick a third person who would serve as a neutral arbitrator. But we're not into arbitration anymore, but this principle of having a person from the nation involved serve on the panel that resolves a dispute is one that's continued on to international courts. You'll find this when we get to the International Court of Justice, as well as the European Court of Human Rights. And so it now results in a process in which if you're now considering a case that's brought in the Netherlands, you're going to have a Dutch judge. I don't think the Dutch judge is always going to be on the side of the government of the Netherlands. It's quite likely that in many, many instances, the judge would provide information about the law of the Netherlands that actually resolves the case against that nation. So look at the practice, but don't assume automatically that the result is tainted by that. I now would like to go very briefly to the European Court of Justice. And I do that not because it's a terribly significant organization for our purposes, but because if we fail to do that, you're going to have confusion when you see the term European Court of Justice. You've got to be sure you do not confuse the European Court of Justice with the European Court of Human Rights. European Court of Human Rights, as we've already said, is an institution organized by the Council of Europe. The European Court of Justice is organized by the European Union. So Council of Europe and the European Union are two separate organizations. There is some interplay between them, which can get fairly complicated, but each has its own court. Although we ought to pause for a moment and recognize that some of the questions that get before the European Court of Justice, although they are labeled as economic issues, may very well be human rights issues as well. Discrimination in employment is an example. And so it's possible to have some overlap between the jurisdiction of these two courts. But if we're able to talk in general terms, the European Court of Justice focuses on issues arising out of EU law, and that means mostly economic issues. And the European Court of Human Rights focuses on issues that relate to the European Convention on Human Rights and its provisions. I don't think we need to spend a lot of time on the organization of the European Court of Justice. There is, again, one judge for each of the UN nations. In 2013, I think that's 27. It also has officials who are called advocates general, who are allowed to make recommendations for decisions. It has a president, vice president, and a registrar. It has a jurisdiction which allows appeals from the General Court of Europe, which is a lower court organized by the European Union. It can take up requests to interpret a point of European Union law. It can handle actions for failure to fulfill obligations, and these would be brought against European Union governments for not applying properly European Union law. Actions for annulment against European Union's laws thought to violate European Union treaties are fundamental rights. Now, in addition to the European Convention on Human Rights, there's also an EU treaty relating to fundamental rights, and that can be applied by either of these courts, but specifically can be applied by the European Court of Justice. It can entertain actions for failure of a government to act and direct actions brought by individuals against EU decisions or actions. Now, having talked about the European Court of Justice, let's put it out of your minds for now. We'll not spend very much time talking about its jurisprudence, and we'll spend an awful lot of time talking about the jurisprudence of the European Court of Human Rights. For that court has provided us most of what we know about how human rights principles are to be interpreted. Only the international criminal tribunals have weighed in with anywhere near to the importance in our understanding of international human rights principles. The court in the world is this court, which covers this vast geographic territory and which has jurisdiction over lands with a population in 2013 of 800 million people. So let's keep our attention to the European Court of Human Rights, and I look forward to your presentations on the jurisprudence of that court.